Welcome everybody and good morning to our fourth forum of the conference. We're talking today in this fourth forum about one of the big areas in which AI and new technologies have been put to use and abuse, and an area in which their relevance, their limits, and the implications of their increased use are discussed with direct relevance for international lawyers. And that's the law of warfare, IHL and other aspects of it. This panel or this forum is devoted to that, giving reflecting the fact that this is one of the big areas in which international lawyers discuss AI. We were meant to have 3 speakers, but as it happens in life, we're down to 2, which I think from an audience perspective is good because it means that we can be serious about the discussion part of it. Of course, you know this from conferences, that is always, all the organizers and all the panel moderators always say that we will have ample time for Q&A at the end, and then it's time for 3 questions at the end, of which 2 are really commons, and there's no real discussion. I hope we can beat that sort of cliche and avoid it, because we will have 2 speakers only. The third speaker, Lian Bohr, unfortunately is not able to present, but the paper that she sent in will be available for those who are interested. So we have 2 speakers, but that's in some ways less than 3, but we have 2 very qualified speakers who will present extremely interesting perspectives on our topic. We have Natalia Händel, who will give the first presentation, and it's entitled The Use of New Technologies During Russia's Aggression Against Ukraine. Natalia is a researcher in Ukraine at the Institute for Information Law and Security, and she's a member of the Interdepartmental Commission for the Implementation of IHL in Ukraine. She has a topic that is applied, focused on a concrete crisis, a concrete use and abuse of modern technology in warfare. She has, if I can add one thing, traveled to Vilnius from Ukraine yesterday. So she has made a probably one of the more adventurous journey of all participants, and we're grateful for the dedication, and I am personally, as a moderator, very happy that you made it. Natalia will speak first. Her presentation will be followed by a presentation by Gentian Siberi, who is a professor of international law and human rights at the Norwegian Center for Human Rights, a member of the PCA and a former member of the Human Rights Committee. I will say a bit more about his topic in a minute. But this is all I wanted to say in opening. The only thing I will say to you is that as you listen to the presentations, think about questions that cut across topics, think about perspectives that are missing. We'll hear 2 presentations in a row, hopefully crisp and to the point. And after that, we will, as I said at the beginning, hopefully have enough time for questions. So if you think about them, we can go through them smoothly. That's all I wanted to say. Perhaps I should have said one thing. My name is Christian Tams. A very great pleasure to moderate this. This is probably what I should have said as the first thing. I'm a professor of law at Glasgow, delighted to be here and delighted to moderate this panel. With that, over to you, Natalia.
Thank you. It's a great pleasure to be today here and presenting a speech of the Ukrainian perspectives to use new technology during this international armed conflict. Today, armed conflicts are inconceivable without new technologies. They are a natural evolution of today's entire technological world. But they also lead to more deadly and inhuman weapons with terrible consequences. But the greatest evil, the most serious international crimes, are committed by human beings. People consciously choose the side of darkness, and technology only helps them in this. The latest technologies are no exception. They have remained the means by which wars are fought, because the military advantage also lies in the use of the latest technologies. This is a reason for the well-known Martin's Clause, which has become a treaty norm of modern IHL. This is why Article 36 of First Additional Protocol requires that new methods or means of warfare be examined for compliance with IHL. The role of new technologies in documenting and investigating war crimes cannot be ignored. Obscene technologies, the use of drones to document the aftermath, the famous drone footage of the execution of Ukrainian defenders by the Russian militaries as they surrounded the use of satellite imagery and seismic data in the investigation of Kakhovka Dam explosion. These are also contribution of new technologies to the mechanism on constrained violence, where information about a crime becomes known almost at the time of the crime, making the fog of war visible and accountability inevitable. But it is preciously these technologies, when turned into weapons, that can contribute to compliance with IHL, as in the case of precision weapons, or they can violate it and make the consequences of the use more horrific. Modern IHL is quite conservative, but at the same time has a wide scope of application, covering most new developments. Of course, this has not always been the case of the development of IHL, has also been influenced by technological progress and the use of new technologies. Therefore, I will continue to assess the use of new technology during the international armed conflict caused by Russian aggression against Ukraine through the prism of IHL. The technologies used, in particular drones and unmanned aerial vehicles, have become an effective and influential means of warfare in the air, on land, and at sea. This application are not entirely new, but the scale, methods, and consequences of their use pose new challenges to IHL. All principles of IHL, including the principle of distinction, proportionality, and precautions, apply to the use of all types of combat drones, whether in the air, on the ground, and at sea. Modern armed conflict combines technological warfare and classic trench warfare. And the international armed conflict between Russia and Ukraine demonstrated both the military and legal dimension of this issue. Depending on the control methods of unmanned aerial system, there are unmanned unguided, unmanned automatic, and unmanned remotely piloted aerial vehicles. The degree of operator invention and the possibility of taking into account IHL norms in combat operation depends. Russia widespread use so-called Shaheds, unmanned aerial vehicles, kamikaze drones, against Ukraine's cities, infrastructure, civilian objects, and civilians, in an example of the systematic use of advanced unprohibited weapons in violation of the principle of distinction, as a serious violation, grave breaches of IHL. Also, as autonomous weapon systems, Shaheds are programmed with coordinate targets that are used not correct by the operator and can hit civilian objects and divert the drone from its target in the event of programming errors, target selection, or electronic jamming. Remotely piloted aerial vehicles of different levels, technical, operational, strategic, are widely used along with the Bayraktar TB2 of the operational and technical level, or the technical level as the Mavic 3 are well known. Drones are used for intelligence, as well as attack drones and munitions drop bombers. The former and later improves the quality of detection and accuracy of target selection, which actually reduce the possibility of accidental hitting of civilian objects. However, deliberate attacks by Russian attack drones on civilians and vehicles are very common, even targeting individual civilians. On 2nd September, for example, a drone dropped explosives in the village of Kindiyka near Kherson, killed a 60-year-old doctor, Volodymyr Terelyuk, and injured a 59-year-old woman. In other words, it was probably intended to target civilians. Ground-based robotic systems are used for firepower as platform for various remotely controlled weapons, for mining and demining, and as kamikaze drones. They are most often manned systems, and their use is controlled by an operator responsible for compliance with IHL. Another dimension of the use of new technologies in armed conflict is aid and assistance, a humanitarian function. Drones can provide humanitarian assistance to civilians during armed conflict. that is vital to their survival. An example of this is Ukrainian military's drones' delivery of drinking water to a family trapped by the water near Oleshkiv after the Kakhovka hydroelectric power station dam was blown up. The next example is the use of robots to evacuate wounded civilians and combatants from the battlefield. In Ukraine, ground robots are being used to evacuate and transport the wounded. A more exotic example of the use of drones is the case of the capture of a Russian soldier, which made it possible to save the soldier's life and to ensure the implementation of requirements of first additional protocols. Such a case occurred in November in 2022, when a Russian soldier, surrounded with the help of drones, that showed him the way to Ukrainian position. Even a special instruction for the Russian armed forces on how to surround it safely was developed using drones. Remote capture reduces the likelihood of a betrayal during surrender. This example demonstrates the importance of distinguishing between technologies used for military purpose, for intelligence, combat mission, and those used for humanitarian purpose, humanitarian aid, evacuation of the wounded. The second issue I would like to focus, if we are talking about technologies during an international armed conflict caused by the Russian aggression against Ukraine, question arises as to the legal qualification of numerous cyber attacks that take place during a war between industrial states, where both military capabilities and the life support of the civilian population and access to humanitarian needs depends on information technology. While the general application of IHL between the belligerent states is undisputed, question arises as to the limits of IHL in the context of cyber attacks. If there are physical consequences, physical harm, such actions certainly fall under IHL. For example, as in the case of the Russian cyber attack on the computer control system of 3 Ukrainian energy utilities in 2016, which led a significant number of civilian consumers, including those responsible for the life support of the civilian population without electricity. We consider these attacks to be a violation of the prohibition of attacks on the civilian objects. The most common question that arises in the case of cyber attacks during an international conflict by a hostile state without direct damage are: can such a cyber attack be considered an attack under IHL? How to interpret the criteria of military objective in relation to the target of cyber attacks when they are databases, banking system, or personal databases? How to apply the principles of warfare to them? There is also the question of civilian personnel involved in such cyber operation, whether they are directly involved in hostilities, especially in the objects of attacks are the above-mentioned targets. In our view, the international conflict caused by Russian aggression against Ukraine will significantly expand the scope of application of IHL to these cases. Therefore, here are episodes that underline the importance of the progressive development of IHL, the inclusion of its application to cyber attacks, and the dissemination of knowledge about it to personnel engaged in cyber operation. In the context of this discussion, as an example, I can specify the cyber attack on the telecommunication infrastructure of Ukraine's largest mobile operator, Kyivstar, which occurred on 12 December 2023. As a result of the attacks, 24 million subscribers completely lost mobile communication and internet. It was also reported that the attacks caused the failure of equipment that used Kyivstar network, including banking terminals. Mobile communication was restored only 2 days later, on 14 December 2023. Open sources indicate mass complaints from citizens who, due to the lack of mobile communication, stop receive air raid alerts and were unable to promptly call for emergency medical assistance. According to Kyivstar management, the company IT infrastructure was partially destroyed. Also, subscribers' personal data was not compromised. The company owners also announced that the losses from the cyber attacks amounted to almost $100 million. Responsibility for the attack on Kyivstar was claimed by one of the Russian hacker groups, which, according to the Security Service of Ukraine, is a hacker unit of the main directorate of the General Staff of the Armed Forces of the Russian Federation, also known the main intelligence directorate. It is noteworthy that this hacker group claimed that the reason of the cyber attacks was Kyivstar provision of communication between the servicemen of the Ukrainian armed forces and government agencies. Following the cyber attack, Ukrainian law enforcement agencies initiated criminal proceedings, including under Article 438 of the Criminal Code of Ukraine, violation of the laws and customs of war, as a war crime. With regards to this example, it is important to highlight the humanitarian component of the use of Kyivstar mobile operator. The function is provided to the civilian population in terms of communication access to internet. And the third issue of the use of autonomous weapon system with artificial intelligence is more controversial. The military advantage is undeniable, but the question of decision-making, compliance with IHL, and control is paramount. It is expected to be used in international armed conflict caused by Russian aggression against Ukraine, and there is already information about the development and use of artificial intelligence-based autonomous weapon system on the battlefield. But in any case, artificial intelligence-equipped autonomous weapon system must comply with the requirements of IHL, in particular its principles of humanity, military necessity, distinction, proportionality, and precautions. In conclusion, it is important to remember that mass murder and atrocities can be mechanized and grow exponentially. These weapons will be weapons of mass destruction. In humanity, ready for this, because it is one step away from reality. We Ukrainians also slept on 21st February 2022 and did not expect that a Russian missile would fly into the defenseless sleep of our children. And in this case, imagine hundreds of drones launched by the terrorist or terrorist state. For this reason, IHL has to be restored and responsibility for its observance has to be strengthened. Thank you for your attention.
Thank you very much, Natalia, for your presentation. Obviously, presentation that has grown out of your own lived experiences, which lends poignancy to it. I think you've given us a helpful and I think helpfully concrete overview of some of the uses of modern technology. If I can pick out one point, then I thought it was particularly instructive that you mentioned destructive uses for military purposes, but also highlighted humanitarian uses of modern technology. You spoke about drone delivery of humanitarian aid, and I think that's an important aspect of the discussion which is perhaps not always fully reflected. And then you've told us about the difficulty of qualifying cyber attacks, and that is also no doubt something to which people will respond in the Q&A. We move on after your presentation to the second presentation by Professor Gentian Siberi from Oslo, who will zoom out, as it were. We've had a first inductive, concrete presentation of specific problems arising in a particular conflict. Gentian will speak about a more general topic or offer a more general perspective, and the title of his presentation is Ensuring Accountability through the main UN human rights mechanisms for the use of new digital technologies in armed conflicts. For those who felt that you were looking all the time to us, you now can switch your heads and move around. That's good for the sort of early morning gymnastics. It's also helpful because we're here sort of blinded by the light, sort of famous song titles. So I can also now look over, sort of slightly avoiding the glazing light of the the lamp there. Look over to Gentian. Gentian, you have the floor. We look forward to your presentation.
Thank you very much. Thank you very much, Christian. I think probably it's good to get some exercise in the morning for those that didn't hit the gym already. Good morning, everyone. Let me start by thanking the organizers for having invited me and for an excellent conference so far, and to our chair, Professor Thomas, for stepping in at the last moment. The topic of my presentation, or the title, has slightly changed, as it's usually the case, and now it's more about ensuring accountability through the main UN human rights mechanisms for the use of new digital technologies in armed conflict. Before I continue, I think the lights blind me a little bit, so I'm not able to see many of you as I would have liked to. I would need your help with a very quick quiz. How many of you think that introducing the new digital technologies in armed conflict, like lethal autonomous weapon systems and artificial intelligence, is a good idea? By a show of hands. Let's see many hands. So how many of you think it's not a good idea? Good. Thank you. Now I can count my paper as having been conducted with mixed methods and being some empirical study of sorts, having consulted at least with one important epistemic community. Now, to the tech enthusiasts out there were not that many, I will meet you halfway by accepting that new technologies in warfare create new questions for us academics to grapple with, obviously also for other professionals. Now, my paper, my analysis, starts with a brief overview of the evolving nature of armed conflict into the digital domain and its implications for international human rights and humanitarian law, norms, and for their implementation. I'll try to look and paint a broad picture of the capability of the main UN human rights mechanisms for ensuring a degree of accountability, and I construe accountability fairly broadly here, to mean anything from just making the facts about violations public to calls for accountability and some kind of remedial action. Of course, as Natalia showed us a moment ago with many concrete examples, the increasing transfer of armed conflicts into the digital domain brings with it a host of challenges that test the boundaries of international human rights and humanitarian law, and the use of sophisticated technologies such as cyber weapons, artificial intelligence, and surveillance and target selection, and the impending advent of lethal autonomous weapon systems, I will refer to them as laws, raise critical concerns concerning the protection of human rights and compliance with IHL. And I take two case studies. We heard about Ukraine. I will also look at Gaza, the occupied Palestinian territory, probably a bit more generally, and try to see to what extent UN human rights mechanisms are able to address the use of new technologies in these armed conflicts. And that will provide a general assessment, at least, institutional approach to the possibilities and limitations of these UN human rights mechanisms in using their investigative and reporting functions. Now, I don't need to say a lot about the evolving nature of armed conflicts and the increasing weaponization of the digital domain with the consequences that entails. But by now, of course, the digital domain has become a very important part of armed conflicts as states compete to have the upper hand, increasingly enlisting the contribution of leading high-tech companies to develop new weapons or tools or to provide material support. And the use of digital technologies has come a long way since the use of telegraph for communication, the advent of radar, and contemporary military uses of technology include the routine deployment of UAVs or drones. It's not a new weapon in that sense, but it has been modernized, and the use of biometrics, including facial recognition, artificial intelligence, and so on. Now, with the digitalization, if you want, if I can call it that, of armed conflict, there's been, of course, a reaction to that from civil society, from less technology advanced states. The international civil society has carried out a campaign from 2013 to prevent killer robots, the Ban Killer Robots famous campaign. And this has been kind of shifted to the discussion at the group of governmental experts on emerging technologies in the area of lethal autonomous weapons systems. That's a mouthful. Under the Convention on Conventional Weapons, with the purported aim of adopting a new protocol to ban them. There has been a push also for banning the use of artificial intelligence for military purposes. And we have a lot of soft law, if I can call it that, in that regard. But I have to say that I get a bit of a deja vu when I think about these developments, or at least efforts to move forward fast with legal regulation, because the alarm bells have been rung already since 2013 from our late colleague, Professor Christoph Heinz, when he was Special Rapporteur on Extrajudicial Summary Arbitrary Execution, with a very important report of April 2013. And if I look at what has happened since then, it's the first UN General Assembly resolution was only adopted then in 2023, and we have finally a detailed UN Secretary General report on laws in July 2024. And the first General Assembly resolution, artificial intelligence, sidesteps the issue of its use for military purposes and focuses on seizing its opportunities for sustainable development. So not much probably has happened. And then in terms of regulating laws and artificial intelligence, of course, Natalia mentioned or referred to Article 36 of Additional Protocol 1. We can consider that as part of custom international law. And of course, we have some rules from the 2005 ICRC study, Rule 70 and 71, which requires states to ensure that any new weapons comply with IHL norms and fundamental principles. If I look at AI regulation, the most recent developments from the European Union, from the Council of Europe, they actually explicitly exclude from the regulatory scope AI systems which are for military purposes, military defense or national security purposes, the EU Act, and whether that's being developed by public or private entities, and Article 3.2 of the, I think probably by now it's called the Vilnius Convention on Artificial Intelligence and Human Rights, Democracy, and the Rule of Law. It excludes those AI systems used for the protection of national security interests, where I think probably use for military purpose will also fall. Natalia also referred to the Martens Clause, and I think the ICJ a long time ago affirmed its importance. But I'm not quite sure if we can go as far as saying that the Martens Clause would ban, per se, the use of laws or the use of artificial intelligence for military purposes. Now, the UN human rights mechanisms work on the use of new digital technologies in armed conflict. The UN has been trying to catch up with developments in the battlefield in armed conflicts, and Secretary General Antonio Guterres has maintained that the laws are politically unacceptable, lethal autonomous weapons are politically unacceptable and morally repugnant, and have called for their prohibition under international law. And his new Agenda for Peace of 2023, which will be discussed now 22-23 September in New York, he recommends for states to conclude by 2026 a legally binding instrument to prohibit lethal autonomous weapon systems that function without human control or oversight and which cannot be used in compliance with IHL. Now, if efforts to adopt a treaty on business and human rights and some other efforts are the standard to go by, then I'm not quite sure that 2026 is really something that we will be able to see through with a new treaty. And there is an effort to prevent the weaponization of emerging domains and technologies and promote responsible innovation. This is going to be the fourth priority area of this new Agenda for Peace, which is going to be discussed as part of the 4 or 5 main points that are going to be discussed in this high-level summit. Now, just very quickly before I go one by one through the main human rights mechanisms, in terms of just highlighting some of the efforts made already. Christoph Heinz in 2013, the Special Rapporteur on Countries on Human Rights, Fionnuala Ní joined the Secretary General call for a global prohibition on laws. And again, this is a report of the Human Rights Council. And we have the Human Rights Council finally addressing these weapons in 2022, General Assembly with a resolution in 2023, and the report in July 2024. So it seems things are moving. The Human Rights Council, of course, is a hub for the development of human rights standards, and it has various mechanisms at its disposal, main methods of work, besides the Universal Periodic Review, which I'm not going to mention a lot, although it's important because it combines monitoring of both human rights and humanitarian law, thematic and country rapporteurs as part of special procedures, and independent inquiry commissions. So this is quite important tools they have at their disposal. The UN special rapporteurs, we have, I think, 60 of them, 44 thematic and 14 country-specific. And some of them have it under their mandate or can interpret their mandate as being able to engage with the issue of use of new technologies in armed conflict. And those would be the Special Rapporteur on Extrajudicial Summary Arbitrary Executions, that on counterterrorism and human rights, and the one on the right to privacy, just to mention probably three of the most important. And they have done so through their annual reports, which are part of the general work on standard setting, if you want. But they have also done, or could do so through visit to countries, if they manage to get there, or they have also issued individual or joint statements, relevant joint statements. Human rights treaty bodies. Now, probably here I can praise the UN Human Rights Committee, not because I was a member there for one mandate, but because in its General Comment 36 of 2018 on the right to life, it has taken the clearest position on the matter of lethal autonomous weapon systems and weapons more generally by stating state parties engaged in the deployment, use, sale, or purchase of existing weapons and in the study, development, acquisition, or adoption of weapons and means of methods of warfare must always consider the impact on the right to life. For example, the development of autonomous weapon systems lacking in human compassion and judgment raises difficult legal and ethical questions concerning the right to life, including questions relating to legal responsibility for their use. And the committee is therefore of the view that such weapon systems should not be developed and put into operation, either in times of war or in times of peace, unless it has been established that their use conforms with Article 6 and other relevant norms of international law. It might be a bit constructive ambiguity there, if you want, but the general tenor, I think, it's quite clear. And in terms of state reporting, the Human Rights Committee has mainly focused on issues concerning the right to privacy, surveillance, things of that kind, and ensuring transparency for the work of domestic intelligence institutions and their oversight. As of yet, at least to my knowledge, there are no individual cases concerning the use of new technologies in armed conflict. A more general approach comes from the CESCR Committee with General Comment 17, who I think was referred to yesterday as well. State parties should prevent the use of scientific and technical progress for purposes contrary to human rights and dignity, including the right to life, health, and privacy. And the more recent General Comment 25 of 2020, concerning risks and promises of new emerging technologies. The CESCR Committee emphasized three elements. First, enhancement of international cooperation. I see major problems with that, and the division along two camps or more. Second, decisions concerning the development and use of these technologies should be taken with a human rights framework and from a holistic and inclusive perspective. And third, calling for regulating the ownership and control of data according to human rights principles. The third committee has done a lot of work on racial profiling and the use of technology to that effect. And the Committee on the Rights of the Child, and also warning against the high risk of discrimination of human rights violations. The Committee on the Rights of the Child has pointed out in its General Comment 2021 that states parties, General Comment 25, state parties should take legislative and administrative measures to protect children from violence in the digital environment, including the regular review, updating, and enforcement of robust legislative, regulatory, and institutional frameworks that protect children from recognized and emerging risks of all forms of violence in the digital domain. So This general comment also addresses the protection of children in armed conflict, migrant children, children in other vulnerable situations. Now, very quickly to the case studies before and then to some concluding remarks. The two case studies, Gaza and Ukraine, were chosen, of course, for three interrelated reasons. First, because it has been reported that new digital technologies have been used during these armed conflicts. Second, because for both conflicts, the UN has taken additional steps for ensuring a degree of accountability by establishing independent inquiry commissions and the position of a special country rapporteur. Also, that on the Russian Federation includes, or part of it concerns the aggression by Russia. And finally, because of the significant international attention that these conflicts have received. A quick perusal of the reports by the respective independent inquiry commission reveals that the use of new technologies during the armed conflict are rarely, if ever, addressed by them. The main focus of these mandates and reports is on serious violations of IHL and human rights in the form of war crimes, crimes against humanity, and genocide. The reports issued for Ukraine note various serious violations of IHL that Natalia also mentioned a moment ago, including killing, torture, and indiscriminate attacks on civilians and civilian objects and infrastructure. Similarly, for Gaza, the focus also on killing and torture, indiscriminate attacks on civilians and civilian objects and infrastructure. And the fact that these reports are not engaged in so much with the use of new technologies might have to do also with the fact that relevant evidence on that use is not easily accessible. Arguably, thematic and country special rapporteurs have a broader mandate that can potentially last longer and than independent inquiry commissions. In her 2023 report focusing on children's rights primarily, the special rapporteur on the occupied Palestinian territory has noted that mass surveillance technologies, including cameras, drones, and social media monitoring, further augment this control, infringing on privacy and leading to arrests for minor infractions. This is the October 2023 report. So that was concluded before the terrorist attacks by Hamas. In her first 2023 report, the Special Rapporteur on Russia and the Russian Federation has highlighted that the Foreign Agents Media Law, which includes information technologies, has been used to severely and arbitrarily restrict the freedom of expression, peaceful assembly, and association. And there seems to be somewhat more attention to the use of technology, new technologies in these reports concerning violations of human rights and humanitarian law. Now, the reported use of artificial intelligence-enabled decision support systems, in particular the Gospel and Lavender by the Israeli Defense Forces in their military operations in Gaza, has been quite controversial. Allegedly, these two systems are used to identify objects and human targets respectively, and as Israeli experts asserted, they are applied at the very preliminary stages of the chain of creating and authorizing a military target. According to Plus 972, MAG's reporting, one source stated that the human personnel often serve it only as a rubber stamp for the machine decisions, adding that normally they would personally devote only about 20 seconds to each target before authorizing a bombing, just to make sure the Lavender market target is a male. This was despite knowing that the system makes what are regarded as errors in approximately 10% of the cases and is known to occasionally mark individuals who have merely a loose connection to militant groups or no connections at all. So just to summarize this part, move to concluding remarks. The extent to which new technologies in armed conflict are addressed by reports prepared by inquiry commissions and special rapporteurs depends significantly on the extent to which such information is available and reliable. And generally, states do not divulge such sensitive information, with some exceptions, or we find that information when it comes out due to leaks and investigative journalism. Some concluding remarks. New technologies come with the promise of humanizing war by making it more efficient and less damaging. The result of the use of drones and artificial intelligence in the two case studies considered have been nothing but devastating. Three developments can be highlighted. I would say probably three negative developments that can be highlighted here. Autonomous weapons include the risk of an emerging arms race, lowering the threshold for conflict and proliferation, including to non-state actors. The use of digital technologies blurs the distinction between combatants and civilians taking a direct part in hostilities, potentially making them into military targets. And it also blurs the distinction between civilian infrastructure and military infrastructure, with tech giants like Amazon, Google, Microsoft, and Starlink providing services which have a military application, potentially turning such infrastructure into a military target. The Human Rights Council should make better use of its special procedures and inquiry commissions by specifying more clearly their mandates to also include the use of new technologies in armed conflict. The UN treaty bodies can provide more guidance, better guidance through their general comments or general recommendations, as well as through the state reporting procedure, although that would be, in a way, the second ex post facto most of the time. When it comes to individual complaints, most states that are using such new digital technologies have not given access to individuals to bring individual communications before the UN Human Rights Treaty bodies. And with Russia going out of the European Convention on Human Rights and Council of Europe, obviously that leaves, that gets them off the hook for a number of these violations. Overall, and leaving aside limitations related to financial and human resources, which are considerable and which we can discuss, UN human rights mechanisms hold significant potential to ensure a degree of accountability for unlawful use of new technologies in armed conflicts, which, in my view, has not been sufficiently harnessed so far. Thank you very much.
Thank you, Gentian, for this overview of how human rights bodies in particular and the human rights world has responded to the new challenge. You've ended by noting that AI and new technologies do bring the promise of a more humanized warfare, but that the experience of the two conflicts that you mentioned suggests that this promise is completely sort of unfulfilled, and what we're seeing is devastation and risk of an arms race. I think the two presentations taken together not only complement each other well in their styles and in their sort of takes on the issue, but also provide us with a good basis for the discussion, which we can now begin. I think we've heard from the two of you that there seemed to be agreement on the panel that the new technologies are perhaps not revolutionary new or nothing unheard of, but they provide new challenges, new risks, and to some extent are very menacing. We've heard an overview of how core audiences of international law seek to respond to that challenge, and in particular what human rights law can offer or what it cannot offer. We've heard reflections on the role of international law. Natalia at the beginning said that IHL is conservative. Gentian has outlined how international human rights law has sought to adapt in response to the challenge. And these are no doubt points for the discussion if you want to take them up. I add perhaps two more points, slightly broadening the angle. I think one thing that struck me when listening to the two presentations is international law really where we should look for salvation in addressing the challenge? It all seems a bit helpless, 10 years too late and far too little. And there's a further dimension which you would have heard far more prominently had Leanne been able to join us here, because that is the focus of her paper, and I simply bring it out in one line. What is the role of scholarship in relation to addressing these challenges? The role of expertise, but also of scholars that might be corrupted in a debate. I think the two presentations offer a good basis for the discussion, and we can now begin with the Q&A. We have, hurrah, 45 minutes for that. So this is an opportunity as much as a challenge for you. Let's fill these 45 minutes with a meaningful discussion. We'll do so in rounds of questions by you, so we're sort of at your mercy in some ways. As you ask your questions, please make sure that this stays a Q&A, and this is not the place for the presentation that you had always wanted to give, and now you feel you can give it. You cannot. You can ask questions, and they're very welcome, but please keep it focused, and please don't hesitate to address particular members of the panel, but let's keep it sort of driven by interest in novel insights as opposed by an interest in giving the third presentation that was missing from the panel. So questions from you, perhaps start your questions by introducing yourself for the benefit of the panelists. I see a few hands, sort of maybe the people who are not quite as blinded by the light can guide me. We start here with a few hands that I see first. I think I see Helmut and Yuval, so maybe you start, and then we see, by then I will have looked around and seen more hands. Over to you.
Thank you so much, Helmut Aust, Freie Universität Berlin. Thank you for two very interesting presentations. My question concerns the potential further normative development, and I would be interested to hear from both of you how you would prefer normative development to take place when it comes to differing capacities of actors. So when you reflect on the technological changes and how they impact on international humanitarian law and human rights law, should there be a development of common standards for all actors involved in conflicts, or do you see the need or the potential to differentiate between states and actors with varying capacities? Thank you.
Thank you very much. This was very interesting, Yuval. Shani Hebrew, you. So I would want to throw to you this proposition for your reaction, and it may have to do with Christian's observation that maybe international law has been a bit helpless here. And the question is whether we have been focusing here maybe in the last decade or so on the wrong target, and that maybe we have spend a lot of time thinking about the end of the spectrum technology, namely the lethal autonomous weapon systems. Both of the case studies Gentian mentioned and were discussed before didn't deal really with fully autonomous weapon systems. And yet they do create these very serious problems, and maybe we should be thinking more about these integrated systems, this human-machine integrated system, and put more focus on how they actually are structured and how they've been actually implemented. So maybe this is a criticism about, would you share the criticism about the discourse that we have been focusing a little bit maybe on the wrong object? And the other question, which is, I think, maybe related, I mean, the other point, and I think you made the observation about weapons of mass destruction, I mean, this analogy. And I think there is something here that could be further discussed. And this, I mean, we know that when we are thinking in a very different context about technology, when we're talking about social media and hate speech, we are concerned about issues such as scope, scale, and speed. And I think maybe for this, and I'm wondering whether it would be useful to think about the unique feature of this technology, that maybe when you look at each individual use of the technology, it would fall within the existing principles of international law, but we haven't really developed a way to conceptualize the additional lethality that you can employ a massive horde of drones that would act within incredible speed and would inflict a huge amount of damage. And I'm wondering again whether we should, in terms of conceptualizing our approach to the interplay between human rights law and the laws of war, think about the aggregate effect of having this technology at hand. Thank you.
I see more hands, but given that these were two relatively weighty, big questions, I suggest we take it back to the panel already here, because they were scribbling, and I fear that if we add more weighty questions, that'll be too much for one round of response. So I would suggest we take it back to Natalia first, and then to Gentian for responses on Helmut's questions about normative change, and Yuval's double questions about the wrong target, and the possibility of using existing categories. And then we have ample time for questions that I've seen in the back. So Natalia, please.
Thank you for your questions. And about the normative changes, I would like to answer this question uses my experience as expert on IHL in Ukraine, as who works with prosecutors, judges, military defenders in Ukraine. When we talk about how use new technologies, we just use the law that we have now. We use international treaties that Ukraine ratified. First of all, it's first additional protocol when we talk about hostilities and use new technologies during these hostilities. And that's why it depends on the level of use in law. First level, it's about when the military forces use these technologies. It's about the commander responsibility. It's about the planning operation and how IHL is implementing in armed forces. In Ukraine, we have an instruction of application IHL in Ukrainian armed forces. That's why all operation that development within Ukrainian armed forces with implication of IHL. That's why, first of all, it's about the principle of warfare. It's about distinction. It's about targeting the military purpose. And we know the examples when Ukrainian military forces use cyber attacks against Russian Federation. That's why it's really important to combine all this principle in the real life. It's first level. The second level is about the persecution and in the court system. Why IHL is important for prosecution, for investigation? Because in Ukraine, now it's open more than 130,000 criminal proceeding under Article 438 of Ukrainian Criminal Code as violation of customs laws of war, as war crimes. That means some cases it's about using new technologies. It's about unlawful use drones against civilians, against civilian infrastructures. And that's why also the prosecutors and the Ukrainian judges use IHL, relevant IHL, that IHL we have today. It's not about the development. We have these instruments. And our main purpose to understand what the relevant provision can be applicable for this situation. Because now we can't opportunity to discuss the new development, because we now in Ukraine, we have these cases, we have this violation. There's only one way to use the rules that are in first of all, in first edition protocol, because Ukraine and Russia Federation ratified this international treaty. About another way, it's about the documenting violation as a human rights violation and its violation of IHL. The Ukrainian civil society, human rights organization do a lot to document these different cases, and that's why we can work with these cases in the enforcement agency, in the international level, in ICC. And I think for Ukraine, it's really important that now Ukraine ratifies the Rome Statute. It's a new way for the development, investigating and prosecuting war crimes. But it's the first level of the ratification, but I think it was adopting the draft of laws of changes of the Ukrainian Criminal Code. And the second question was about weapon mass destruction. I think it's a really important question, because we saw what it means when 100 drones attacks your countries. We hear this, we saw this, we know circumstances about this. But imagine what will if these 100 drones had more powerful and destroy cities, all cities, that killed millions of people. And it's not about some fantastic. It's a real situation. It can be a real situation. That's why the role of international law is really important, because international community, all states, academia, and other stakeholders, and all of us can change the situation and attention for uses autonomous weapon system as a mass destruction weapons, because it depends only how powerful these drones will be.
I guess this is working, yes. Thank you very much, Helmut and Yuval, for very good questions. I'm not quite sure if I understood your question correctly, Helmut, but with the technological changes and the developments, then I understood it if you're asking whether we should see whether we're going to address different actors in different ways. And if that was the question, then I think indeed that is already happening, because UN special rapporteurs, when they address the recommendations, they're addressing them to states, they're addressing them to international organizations, businesses, non-state armed groups. So there's they are addressing this to different actors, and increasingly also the UN treaty bodies are doing the same in the general comments, general recommendations. primarily states, obviously, but also other actors, increasingly business, because in this case, when we speak about the development of new technologies, use of new technologies in armed conflict, I think these new developments are being brought primarily by technologically developed states and some of the tech giants. So we know who the actors are, or the main actors are, in a sense, most of the time. So in terms of, but what is problematic here actually in terms of addressing that I tried to highlight is the fact that 10 years after the alarm bells have been rung, at least officially by the late Christoph Heinz, the UN is still catching up. And when the UN Secretary General says by 2026 we have to have a treaty banning laws, then I'm not quite sure if we're going to reach that aim in a way. So quickly, if I look at what has been happening in the discussions in the expert group under the Conventional Weapons Convention. So the reflection, Yuval, about looking more maybe at the human-machine integrated interaction and so on, and focusing on that instead of focusing on efforts maybe to ban lethal autonomous weapon systems. I think that's an interesting proposition in itself, but again, it's quite problematic because ultimately, I didn't highlight it, but what is the difference between semi-autonomous and an autonomous weapon system? It's a line of programming, basically, right? Check with operator before engaging the target most of the times. So there's one line in programming that stands between fully autonomous and semi-autonomous. So we're almost there in that sense. It hasn't been reported that fully autonomous weapons have been deployed, but I think we're far from that. And that changes significantly not only how we think about IHL, but also changes significantly how we go about the law on the use of force, because it lowers the threshold and creates an arms race and all the negative things that come with that, while we should be thinking more about, I think, sustainable development, climate change, and so on, instead of how to kill more people more efficiently, while paying lip service to the to IHL fundamental principles. We have also to take into account that armed conflicts are happening in densely populated areas. I mean, Gaza is densely populated, 365 square kilometers, 2.3 million people, right? So, and now they're squeezed into 10-15% of the population because of the displacement orders. So that is quite problematic. If we look at Ukraine, again, we see indiscriminate attacks on civilian infrastructure and civilians, and especially schools and hospitals. So it doesn't look to me that the technology actually that we have is indeed being used for precise targeting. In fact, it's being used to amplify the damage. So it's completely the opposite of what is purported to do. I will finish with a remark about the testing of these new technologies, right? The testing of weapons, and the fact that it is not quite clear, actually, to what extent and who is doing the testing, and whether there is, we don't have much oversight on a number of things. And in that sense, then I would agree with you and your suggestion that we need to focus also a little bit more into this nitty-gritty of the development of new technologies, and have a little bit more clear and detailed guidelines, not only a more general article like Article 36 or broad customary IHL rules.
Okay, thank you, Natalia. Thank you, Gentian. Let's go over to the second round. I think there was one hand that I see here, and then we start there, and then we go over to the center.
My name is Kaja Kowalczewska, and I will stand up because I was sitting there yesterday, and I know how you can feel now with lights and heat. So I have two questions. One is about the arguably customary nature of Article 36. I would like to ask about, like, we have this rule, but it's not being implemented. And maybe I would like to hear your thoughts about how this kind of mechanism can actually be helpful in the discussions on new technologies and warfare. And the second one is about human rights, which I'm not an expert, but I would like to take a chance that we have here the expert that was involved, I understand, in drafting of General Comment 36 to Article 6, and ask about so how the human right to life of soldiers can be included in the development of the new technologies, because like this very broad wording of that states should consider right to life when using new technologies. And I guess like we would hear in many forums, autonomous weapons and cyber and other new technologies are there to save some lives and some protect some right to life. So I would like to hear your thoughts on those two things. Thank you.
Over here to Markus.
Okay, thank you very much for the presentations. I'm Marcus from Singapore. I just wanted to say that, to me, the most important thing is compliance with international law. So human rights law, humanitarian law, these are important components. If the use of AI, if the use of lethal autonomous weapons improves compliance with international humanitarian law, if the use of lethal autonomous weapons is used in a defensive way, for example, perhaps the Iron Dome, phalanx systems and all that, is that something which is acceptable? So laws, can they be used for defensive purposes and they're okay, but not if they are used for offensive purposes? Yeah, thank you.
Let's include one more question. I think Nicholas, I think, was first, and then we take it back to the panel, and then I think, Paul, you're in the next round.
Okay, thank you. Paul Wrangel, Stockholm University. This question is doctrinal in a sense, but it's also about the efforts or the necessity or the difficulty in sort of fitting new phenomena into established language. So, Dr. Handel, you mentioned Russian cyber attacks against civilian computer systems. And one contested question in IHL and with regard to cyber operations is whether civilian data, health data, census data, whatever, is protected as civilian objects. And some scholars and states think that it is not, because data is not objects, it's not tangible. And they actually rely here on something in the ICRC commentary, which defines civilian objects, or which defines objects as anything that is tangible. Whereas the current ICRC position is that civilian data is protected as civilian objects, because that is in line with the object and purpose of IHL. So I would like if both of you, but perhaps in particular Dr. Handel, could reflect a little bit on that. Thank you. Shall we do it?
Let's take it back to the panel. Three more specific questions. Gentian, do you want to start first this time? And I think, as a general point, feel free to be selective in your responses. We can pick up on the missing bits sort of in a further round.
Thank you very much. I'll try to be very brief. For the first question, the customer IHL nature of Article 36. Yes, we have Article 36. It's Additional Protocol 1 has been ratified by a lot of countries, but and we can accept that there is a customary law nature of Article 36, but it is fairly general. So we need, I think, a little bit more details. I would argue along those lines. And the other question, we have somebody here that was involved in the drafting of General Comment 36. And I think one of the important things that it did in terms of pushing the envelope, if you ask me, concerns the right to life of soldiers and connecting that to a war of aggression and looking at that as some kind of a violation of the right to life also of soldiers. So That is an important development, if you want, of the covenant of the ICCPR. Whether that is accepted by all countries, that is something that we'll have to find out. The question on artificial intelligence and lethal autonomous weapons, whether we should have them or should be allowed if they're used for defensive purposes instead of offensive purposes, then I think what is offensive or defensive depends on the eyes of the beholder, right? So once you have them, then of course that creates major problems. It will create arm races. We see more countries actually, because of the situation, spending a lot more on weapons and arming themselves, while we have also major challenges concerning sustainable development, transitioning to a green economy, climate change, and so on. And if countries are looking at each other as enemies, then you can imagine how much progress we're going to make with, at least, if we have problems with international peace and security, then I'm not quite sure how much progress we're going to make then with sustainable development and human rights as two other main pillars of the UN. So for me, it's quite problematic, actually, their use, and this doesn't help us much in that sense. Finally, I think I said it before, I see an emphasis on soft law. States, of course, they don't want to have more binding obligations, but this shift of regulating these new technologies, Tallinn Manual on Warfare, wonderful piece of work, other efforts, wonderful efforts by colleagues, experts, which should be praised for doing that kind of work. But it is problematic because then states, when push comes to shove, they probably are not going to comply with them. So we need to put more pressure, and I think we need to have at least more binding instruments, in the sense that at least then we can use them in terms of ensuring responsibility for states and for individuals for violations.
Okay, Natalia?
I would like to start with answer about the customary law and about the relationship between human rights and IHL and life as soldiers. All answer for these questions, all my answers, it's only answer for my experience in the field when we work practically with IHL. That's why I focus on the approach we use in Ukraine national legal system. And answer for this relationship between IHL and human rights, all compliance of international law, IHL and including human rights, depends on respect of international law. If state, agencies of state, military forces of state don't respect norms, don't respect rules, don't respect international law, human rights law, IHL, how we can protect all victims, civilians, prisoner of war, wanted person, wanted combatants. If state, armed forces of this state killed prisoner of war, how we can answer about the respect human rights, right to life? It's not about the respect, it's about values. International law, human rights is a values, and it depends what approach state uses for this law. Only this is mean. And we can talk a lot about human rights and IHL's lex specialis, how it's about this relationship, but we have a lot of numbers of violation of human rights in occupation and violation of IHL in this war. And that's mean, first of all, it's really important to comply with IHL as it's mentioned in the first article common for Fourth Geneva Convention, respect. It's about the respect, it's about attention of law. And another question about cyber operation and about targeting and how distinguish between civil objects and military purpose. In national legal system, we can use for legal proceeding only the treaty norms. That's why when we work with this violation, with this situation, we use the definition which mentioned in first edition and protocol. That's why when we work with a cyber operation, we should understand what's the military advantage, what the military purpose was. And then we use, if we talk about that no military advantage was in this operation, we focus to the civilian characters of this with these databases or communications or another technologies and another cyber then that's why first of all in the first step it's about the principal distinction. Then, when we understand that it's absent the military necessity and this target is not the military purpose, we work as these objects is a civilian objects because it's only one way that can be used to build the criminal case in Ukrainian national legal procedure. Because our criminal law, our Ukrainian Article 438 is blanket norms, as it mentions that we use all the ratifies all international treaties which was ratified by Verkhovna Rada of Ukraine, and only for cyber operation is applicable the first edition protocol in our understanding for criminal cases.
Third round, I think final round. I think we have probably 4 questions left. I think Nicholas Zagurios was going to go first, and we have 2 questions in the back, and I think I see one over there. But please keep it crisp and focused.
All right, thanks, Christian, and thank you for the excellent papers. I'm quite skeptical as to whether we can have accountability in the case of autonomous weapons, and for 3 main reasons. The first is legal uncertainty. The law is uncertain, what is military target, and it needs interpretation, ad hoc interpretation, for example, in the case of proportionality, so the weapons cannot be programmed accordingly. The second reason is lack of explainability. So we cannot explain how these weapons make decisions, and they don't record their decisions. And the third reason is lack of evidence and the difficulties in acquiring evidence. So what you can say to convince me that we can have accountability for autonomous, in particular for autonomous weapons? Thank you.
Thanks to the speaker, Giulio Bartolini, Roma Tre University. I have a question for Natalia. You touched the point of the issue of surrender and the issue of drones, which of course is quite a new emerging point. So I'm curious about to know a bit more about the practice of Ukraine, and for an issue which I think should need soon a sort of identification of some standards and procedure. I'll just give you an example. We are now drafting the National NHL Military Manual for Italy, and we're interested to touch a bit this point, but of course we face with the point that there is no common standard procedure so far, so maybe that could be an issue where soon ICRC and some group of states could engage in order to identify something which could be used, and maybe the Ukrainian example could be a starting point for that.
Yali Shereshevsky from the University of Haifa. My question is to Natalia. I think the Russia-Ukraine war is really an interesting case in the sense that we have 2 countries that use relatively similar technologies in the battlefield, and it came also in your presentation. And I think that it brings forward the question of what is the concern here? Is it compliance or the technology itself? And from what you said, it seems like there's one party who is able to comply with the rules, even though it uses all these types of new technologies that may raise concerns, and from the other side, there are lots of violations. So I wonder, can you point to specific cases where the problem or the concern is the technology itself rather the willingness of the parties to comply with the rules?
We have one final question from over there. Thank you.
Thank you. Giacomo Biggio from the University of Bristol. I have a question for Natalia with regards to the qualification of cyber attacks. So, assuming that we're moving towards an interpretation of what constitutes a cyber attack that is not limited to physical damage, right? So, non-kinetic effects. You mentioned the Kyivstar hack. How do we then apply the principle of proportionality? Because the principle of proportionality has been exclusively concerned with incidental damage, interpreted as physical damage. And several states do not think that, for instance, economic damage would fall within the meaning of this term. So would the principle of proportionality be able to be applied effectively? And if not, would a complementary solution is to consider objects such as the internet, for example, objects indispensable for the survival of the civilian population in certain circumstances? So to have a more broad-ranging prohibition against certain kind of cyber operations. Thank you.
Hi, Caleb Wheeler from Cardiff University. Thank you both. First of all, really excellent talks. My question really is for Natalia. I agree with you that compliance with international laws about respect for the law of values, et cetera. But I'm wondering then, how does that square with the Ukrainian government's decision to make an Article 124 declaration in their ratification of the Rome Statute, therefore excluding Ukrainians from the jurisdiction of the court for the next 7 years? How does that square with this notion of respect, values, et cetera?
Okay, thank you. So we had a Natalia focus in the last round of questions. You've been processing quite a lot of information. Maybe Gentian, you start with the accountability question in particular, and of course feel free to expand. And then Natalia has a bit of time to respond to the 4 specific questions that were addressed to her.
Thank you. I'll be very brief on the issue of accountability. Thank you, Nicholas. I think what you just said, I think, is another argument as to why actually we should ban these weapons, right? An armed conflict, war, is a public act, and if we can't really ensure responsibility, accountability for the use of these weapons, then I guess probably one way to go about it might be to not use them, to ban them. I want to make one final remark. Liane was not able to be here with us, but I think her presentation about the role of scholars in regard to this, I think, is very important. And I think as scholars, we have an important role to play, because when we're speaking about the use of new technologies in armed conflict, we have to speak out, we have to be more vocal. I don't think we need to see ourselves as powerless, because all of us have broad networks. We have a public voice, and I think we need to use that to ensure that we're not blindly walking into an era of automated warfare, where an alliance of tech-advanced states, there are about 15 or 20, with some of the tech giants, can create major problems for international peace and security, but also for compliance with humanitarian law and international human rights.
Maybe I will start with answer about the Article 124 of the Rome Statute and why Ukraine used this right to clause and to use this provision of this article. And this answer for this question has a long history. It's about the way of Ukraine have a lot of political circumstances about the ratification of Rome Statutes. This way started in 2000, and when Ukraine signed the Rome Statute. And then was a lot of sabotage and discussion and disinformation about the Rome Statute. That's why in 2001, Constitutional Court had a decision that Ukraine can't ratify the Rome Statute because it violates the provision of Ukraine Constitution. And there was another step of the relation between the ratification of ratification Rome Statute in Ukraine. We know about the provision of agreement between Ukraine and EU, and that means that Article 8 provides that Ukraine should ratify the Rome Statute. And we have the new round of changes of Ukrainian constitutions. And then we have the special provision, the new amendments of Ukrainian constitution that provides that now, after this, Ukraine can ratify the Rome Statute. But we should understand that since 2014, when Ukraine, the international armed conflict started in Ukraine, a lot of disinformation was in Ukraine about the Rome Statute. A lot of Ukrainian military forces, soldiers, don't understand that if they will respect IHL, if they don't commit war crimes, the International Criminal Court have not this opportunity to investigate these cases because it's about the compliance with the IHL. And now we have the new stage of this history of the ratification. All these stages, all these relations, it's only political circumstances of ratifications. And a lot of intent factors influence for ratification. First of all, it's attention for the ICC, understanding what the complementary is. Why it's important that Ukrainian national legal system should be strong, and Ukrainian court cases and Ukrainian investigation and Ukrainian prosecution should be with respect and compliance IHL and another international norms. And only this reason, only these circumstances influence about that Ukraine use this opportunity on the Article 1, 2, 4. Because if Ukraine didn't use this clause, we have a lot of political manipulation in national level of the Rome Statute. And it's pressure of military forces and another political parties will be huge. And that's why current national authority, President of Ukraine, chose this way. In these circumstances, it's only one way for ratification, because this disinformation influence was really huge. And we can match the sabotage of the ratification of Ukraine in the national level. And another one, and I think my personal view that it was really win of Ukraine of use this opportunity of Article 1 to 4 for ratification of Rome Statute, because it's a huge stage for future of Ukraine. And about the liability for use of autonomous weapon system. In the case of violation of IHL, in the use of autonomous weapon system, the question arises to the identification of subjects of liability. The operator of autonomous weapon system may be liable if his actions are based on a direct or indirect intent, a committee of violation of IHL. In the case of the use of an autonomous weapon system without the intention of committing a violation of IHL, which nevertheless result in violation, the assessment in whether the operator was aware of the possibility of violation of IHL, if the system was used in a certain way, if there was such awareness, the assessment is whether the risk of violation of IHL was substantial. If such a risk was substantial and upset the balance between humanity and military necessity, the operator of an autonomous weapon system is liable for violation of IHL. And another situation, when we talk about when the autonomous weapon system used without an unnamed person, without a named mechanism. And that's why we should talk about the responsibility for commanders for who use this autonomous weapon system for military purpose. That's the first direction. The second direction is about the state responsibility. Who takes decision for you to use this autonomous weapon system in this battlefield. And as I remember correct, it was the question about the principle of the proportionality of the cyber attacks. And we can took as an example as specific cyber operation, because in Ukraine and we have a lot of experience of this. That's why if we talk about the attacks for civilian infrastructure, we saw this damage for civilian objects, for electricity system, and how many Ukrainians civilians can't use electricity as for their health, for the education. And that's why when Ukrainian enforcement agencies open the criminal cases, criminal proceeding, or under Article 438, they use a lot of expertise and a lot of data and evidence about to amount this damage as for objects and as for human. And that's why we can use the principle of proportionality and understand was the military advantage for this operation or not.
Okay, thank you, Natalia. I think we have to leave it at this. We can continue the discussion over the coffee break. Let me just say that I think we've touched on many things. I'm grateful. I was sorry to miss Leanne's paper, but I was grateful we had meaningful time for questions and answers. It seems to me we have perhaps also displayed some of the usual habits of international lawyers approaching new technologies, some feeling of being overwhelmed by the new challenge, some pragmatic approach of let's use the tools that we have, let's adapt them, some thinking about whether we need new tools, or perhaps reflection on whether we're looking at this from a too limited perspective. Is all of that enough? I think, are we regulating, I think Yuval's point from the first round of questions, from the wrong angle? I think those are points we can continue to discuss in the coffee break, which we can now enjoy. Please do enjoy it and do continue the discussion, but don't go into the coffee break without having thanked once more Natalia and Gentian. And please let's also and I would have said let's also include Leanne, whose absence has permitted us a long discussion, but whose presence we have missed. Thank you all.